Well, that's right. We put up with one another for a long time, and I know he gets back to visit every county in Iowa every year. Is that correct?
Every year for 42 years, and it's a Q&A with my constituents. It's not just like Bob Dole saying, I went through the county and smelled the flowers. See,
And do they treat you okay when you go back to the counties?
almost always.
That's great.
But Iowans, if they disagree with me, they're still agreeable.
Well, I can tell you that I've enjoyed our relationship over the past 2 years. I don't know what your caucus rules will do to you next, but congratulations on your reelection. I see that we have a number of my colleagues here, and I'll make a few opening remarks and then turn to them. Today we'll hear from 6 judicial nominees. Judge DeAndrea Benjamin, nominated to the Fourth Circuit. Judge Robert Ballou to the Western District of Virginia. Judge Todd Edelman to the D.C. District Court. Kimberly Evanson, nominated to the Western District of Washington. Justice Myung John, nominated to the District of Massachusetts. And Judge Colleen Lawless, nominated to the Central District of Illinois. This is an impressive slate of nominees with a broad range of experience, over 50 years of judicial experience represented by this slate of nominees. They've served as prosecutors, public defenders, civil rights attorneys, and I welcome the nominees and their families. We have several colleagues who are joining us today to introduce nominees, and I will introduce 2 of them. First, I'll introduce Judge Colleen Lawless, nominated to the U.S. District Court for the Central District of Illinois, comprised of 46 counties. Judge Sue Myerscough is set to take senior status, and I hope to fill the bench as quickly as possible. Thankfully, in Judge Lawless, we have an outstanding nominee ready to take on the responsibility. Currently serves as Associate Justice on Illinois 7th Judicial Circuit. She's been sitting in that position for 3 years. She's presided over approximately 125 bench trials in domestic relations and proceedings involving mental health commitment, small claims, evictions, traffic violations, and emergency protection. Notably, Judge Lawless has never been reversed. Before her appointment, she practiced with the Springfield firm of Londrigan, Potter, and Randall, conducted 2 solo jury trials within a year of admission to the bar, and tried 4 cases to verdict before a jury. As a practicing attorney, she's handled cases implicating a range of issues from family law to employment to civil matters. A native of Joliet, Illinois, received her BA from Illinois Wesleyan, JD cum laude from Northern Illinois University College of Law. I join with Senator Duckworth in thanking the Judicial Screening Committee, which we rely on to produce candidates for these vacancies. The committee is chaired by Judge Ronald Spears of Taylorville, Illinois, who served as a 4th Judicial Circuit judge from 1993 to 2015. I appreciate the hard work put in by Judge Spears and his committee, which consists of Don Jackson, Rebecca Johnson, Nicola Sharp, and Ruth Waller. Judge Lawless, congratulations to you and your family, and look forward to hearing from you. Also on today's panel is Judge Robert Ballou, nominated to the U.S. District Court for the Western District of Virginia. I know Senators Warner and Kane were hoping to be here today, but there's a highly anticipated opening of the Silver Line Metro to Dulles Airport, which they have to attend. I'm sorry they can't be here, but their statements will be made part of the record. Judge Ballou has had an accomplished career as litigator and magistrate. Received his undergraduate degree and law degrees from the University of Virginia before clerking for Judge Peter Beer of the U.S. District Court for the Eastern District of Louisiana. Judge Ballou began his career as an associate at the law firm of Christian Barton, working on a variety of civil litigation. He then moved to Johnson, Ayers, and Matthew as an associate, then a member of the firm, and with more than 2 decades of litigation experience, Judge Ballou has tried more than 50 cases to verdict before a jury. In 2011, he was appointed to serve as magistrate for the Western District of Virginia, where he's presided over 300 cases. Experienced litigator and jurist, I look forward to hearing from him today. I now turn to Senator Grassley for his opening remarks.
Yeah, very short statement. I hope it doesn't mean that you think I don't take these responsibilities of this committee seriously. I do. So I'm going to say that because of scheduling, I may only be able to ask questions of the first panel, but I'll have written questions for district court nominees. All of you have served as a judge. All but one nominee has, so I hope that we can have a productive conversation about judicial philosophies. I put the rest of my statement in the record.
Thank you very much, Senator. First is Senator Murray, who is here to introduce Ms. Evanson. Senator Murray, congratulations to you on your reelection. We're glad to have you here in the Judiciary Committee. Please proceed.
Thank you, Mr. Chairman. Thank you to Ranking Member Grassley and to all the members of the committee who are here. It is my honor today to introduce Kimberly Evanson, President Biden's nominee to the Western District Court of Washington, who I was very proud to recommend. Raised by two former Washington State public school teachers who are here with us today, Kimberly has dedicated her career to serving Washington State. After earning a merit scholarship to Seattle University, she was a Harry S. Truman Scholar before attending Georgetown Law. After law school, Kimberly clerked for Judge Emmett Sullivan on the U.S. District Court for the District of Columbia before returning home to Washington State to practice law. Throughout her career, Kimberly has earned the respect of her peers and her opposing counsel through her work on cases of public importance. That work earned her a well-qualified rating from the American Bar Association, and as all of you will get to know her through the nomination process, I'm sure you will see why. She also comes with the recommendation of my bipartisan Judicial Nominations Committee, who cited her proven experience, commitment to fairness, and knowledge of Western Washington and the unique issues our communities face, and that is second to none. In her work in Seattle, she has regularly advised clients on constitutional and statutory questions around the First Amendment, compliance with the Americans with Disabilities Act, and a range of other very complex legal questions. Each time, she has done so with grace, compassion, and an expertise in the law that helps steer cases towards a just resolution. Kimberly also maintains a significant pro bono practice where she works with the Seattle Clemency Project and the Western District of Washington's Federal Civil Rights Legal Clinic to provide legal counsel in cases involving access to justice, employment discrimination, housing discrimination, and more. Washington State deserves judges who will carefully review each case on the merits and show respect for the law and everyone that appears before them. There's no doubt in my mind that Kimberly Evanson has what it takes to do just that. I urge each member of the committee to support her nomination to the Western District of Washington State. Thank you.
Thank you, Senator Murray. We know that you can't stay with us any longer, but we certainly appreciate your appearance before the committee. Thank you. Senator Markey?
Thank you, Mr. Chairman, Ranking Member Grassley, members of the committee. I am pleased to be here today to introduce Judge Myung-Jun, nominee to the United States District Court for the District of Massachusetts. And I want to thank Senator Warren for being such a great partner in our judicial nominations process that has led to strong candidates for the Massachusetts Federal Court like Judge June, and we enthusiastically endorse his candidacy for this post. Judge June is joined here today by his wife, Sue, Justices Lisa Grant and David Breen of the Boston Municipal Court, and friends and colleagues. Judge June's two sons are proudly watching their father from home right now. Judge June has a uniquely American story. As a child, his family emigrated to the United States from South Korea with only a few dollars in their pockets. He was raised by his single mother, who earned a living as a seamstress. He attended the New York City public schools, served in the Massachusetts National Guard, and graduated from the University of Massachusetts, Boston, and Suffolk University Law School in Boston. In private practice, including at his own law firm, Judge June litigated extensively before Massachusetts state and federal courts, eventually earning an appointment as a justice of the Boston Municipal Court. Judge June has shown a particular commitment to access to justice and civil rights. In private practice, he often took on cases involving police misconduct, wage theft, and housing violations. As one of his many colleagues writing in on his behalf put it, Judge June's professional life has been devoted to working with people who need legal assistance but are unable to navigate the system because of language, financial, or educational barriers. Judge June has also consistently given back to his community. He has held leadership roles in organizations such as the Asian American Lawyers Association of Massachusetts, the Massachusetts Bar Association, and the National Lawyers Guild. And for many years, he has taught trial advocacy to law students. Over the course of his career, Judge June has exemplified the highest standards of the legal profession. He is a dedicated public servant who will bring knowledge, experience, and compassion to the Massachusetts Federal District Court. And as the first Asian American man to serve on our Federal District Court and the first Korean American judge to serve on a court within the First Circuit, Judge June will be a trailblazer. I have no doubt that he will continue to serve the people of Massachusetts with outstanding distinction, and I look forward to his confirmation.
Thank you, Senator Markey. Senator Warren.
Thank you, Chairman Dermott and Ranking Member Grassley. I apologize for my tardiness. I got held up over in the Banking Committee. I appreciate this opportunity to come before you to introduce Judge Myung June, a nominee to the District Court of Massachusetts. Senator Markey and I have a strong partnership on judicial nominations, and we were proud to recommend Judge June to President Biden for his appointment to the federal bench. Judge June comes before this committee with 8 years of judicial experience, having served as an Associate Justice on the Boston Municipal Court since December of 2014. Prior to joining the bench, he was a solo practitioner specializing in criminal defense work and in plaintiff civil rights litigation from 2007 to 2014. Before starting his own practice, almost all of Judge June's work centered on civil rights litigation in the federal courts. Judge June also served as a member of the United States Army in the Massachusetts National Guard from 1990 to 1996. When he was first contacted by then-Governor Deval Patrick about an appointment to the bench, Judge June turned down the opportunity to be nominated to a higher court and instead expressed his desire to serve on a community court, a place where he could be in close daily contact with those facing life's most challenging circumstances. Judge June's experience on the Boston Municipal Court and in practice as a criminal defense and civil rights lawyer has equipped him with an intimate understanding of the everyday problems faced by those who step foot through the courthouse doors. Ahead of his hearing, the committee received several letters of support from representatives across the Commonwealth, attesting to Judge June's work ethic, to his character, and to his qualifications to serve on the district court in Massachusetts. Those who know him best describe him as a, quote, person of deep integrity, who has the, quote, intelligence, demeanor, experience, temperament, and judgment to serve with excellence on the federal bench. Two assistant district attorneys in Suffolk County highlighted how Judge June has taught them to, quote, look beyond the charges in a case and to see the persons involved, and to seek, quote, the sense of balance that every prosecutor needs in their pursuit of justice. A native of South Korea, Judge June came to the United States along with his mother and siblings with less than $50 in hand. Despite the many obstacles he faced, his hard work, dedication, and commitment to justice has now brought him to this moment. As the Asian American Lawyers Association of Massachusetts expressed in their letter of support for his nomination, Judge June's, quote, story reflects the aspiration of all of those who have immigrated to this country. Judge June has served his country in many ways for his entire life. I am confident that he will continue to faithfully serve the people of Massachusetts by demonstrating his steadfast commitment to the rule of law and to equal justice while on the federal bench. Once confirmed, Judge June will be the first Asian American man, as Senator Markey said, and the first Korean American to serve on the district court in Massachusetts. I am proud to support Judge June's nomination, and I am glad that he is joined today by friends, by colleagues, by his wife Sue, His two sons are also proudly watching this hearing from home. I want to congratulate Judge June on his accomplishments and thank the committee again for the opportunity to introduce him this morning. Thank you.
Thank you, Senator Warren and Senator Markey, for joining us today. I know you have a busy schedule, and thank you for appearing before the committee on behalf of your nominee. We now have a singular honor in the presence of the whip of the House Democratic Caucus from the Palmetto State of South Carolina, our friend and colleague, Jim Clyburn. Congressman Clyburn.
Thank you very much, Mr. Chairman, Mr. Ranking Member, and members of the committee. It is my pleasure to be here today and to offer to this committee the nomination of a longtime friend. It's my great honor to introduce DeAndrea Benjamin, whom I was pleased to recommend to President Biden for nomination to the United States Court of Appeals for the Fourth Circuit. I've had the pleasure of knowing Judge Benjamin for her entire life. Her parents, who are with us today, Donald and Adrian Gist, and of course her husband, Stephen Benjamin, the former mayor of the city of Columbia, have all been fixtures in South Carolina's capital city for many years. Judge Benjamin has distinguished herself as a valuable member of the Judiciary. She currently serves on South Carolina's 5th Judicial Circuit and previously served as a City of Columbia municipal judge. She has experience as both a prosecutor for the 5th Circuit Solicitor's Office and the State Attorney General's Office. Earlier in her career, she also served as an attorney with the Gist law firm. In addition to the diversity of her experience in the legal profession, Judge Benjamin brings a diversity of other experiences that will enable her to be an effective appellate judge. She graduated from Columbia High School, Winthrop University, and the University of South Carolina Law School, all public institutions in South Carolina. She is active in the civic life of Columbia and has served on the board of many nonprofit organizations. Judge Benjamin has also participated in the Liberty Fellowship Program and the Aspen Global Leadership Network. And perhaps her most important role as being the mother of her two school-aged daughters who are accompanying her here today. I believe her nomination to the Fourth Circuit sets an example for those girls, my granddaughters, and others similarly situated that anything is possible. With that, Mr. Chairman, Mr. Ranking Member, members of the committee, I am pleased to present Judge DeAndrea Benjamin.
Thank you, Congressman Clyburn. We appreciate your presence today. The next person I'll recognize is a friend of many years, and we're happy to have her before the Senate Judiciary Committee, the delegate from the District of Columbia, Eleanor Holmes Norton.
Thank you very much, Chairman Durbin, Ranking Member Grassley. I appreciate the opportunity to introduce Judge Todd Edelman and to speak to you in strong support of his nomination for the U.S. District Court for the District of Columbia. I appreciate that President Biden has given me senatorial courtesy for judges on the U.S. District Court for the district, among other federal positions. I recommended Judge Edelman to President Biden for this vacancy. Judge Edelman is a cum laude graduate of both Yale University and New York University School of Law, where he was a Roots Tilden Scholar. He clerked for Judge William B. Bryant of the U.S. District Court for the District of Columbia and was a fellow in the Criminal Justice Clinic at Georgetown University Law Center through the E. Barrett Pretterman Fellowship Program. Following his clerkship and fellowship, Judge Edelman joined the D.C. Public Defender Service, where he served as a trial attorney for over 8 years. During that time, he was also a supervising attorney, chief of the serious felony section, and a training director. Judge Edelman then became of counsel at Brithoff and Kaiser, PLC, where he represented labor unions and pension funds in complex civil litigation in both federal and state courts nationwide. In 2010, Judge Edelman became an associate judge of the D.C. Superior Court. He has presided over cases in the felony branch of the criminal division, the domestic violence division, and the civil division. Judge Edelman has clearly demonstrated that he possesses all the necessary qualities to be a federal district court judge. He has the intelligence, temperament, and integrity for this position. Again, I thank you for allowing me to introduce Judge Edelman.
Thank you very much, Delegate Norton, and thank you, Congressman Clyburn, for joining us today. And we are now going to proceed to the next stage of this hearing, which will be the testimony and questioning of the nominee for a circuit court. So I ask Judge Benjamin to please approach the table as we put the name cards in the right position. Please remain standing. Please raise your right hand. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that the nominee has answered in the affirmative. Judge Benjamin, now it's your turn. Please take at least 5 minutes and tell us a little bit about who's here today in support of your nomination, and introduce yourself to the committee. Thank you.
Thank you, and good morning, Chair Durbin, Ranking Member Grassley, and members of the committee. I would like to thank you for the opportunity to appear here before you today. I would like to thank President Biden for his confidence in me and nominating me to the Fourth Circuit Court of Appeals. I would like to also thank my home state senators, Senators Graham and Senator Scott, for their support. A very special thank you to Congressman Clyburn for his continuous support of me over the course of my career. I would not be here before you today without the support of my loving family. I am blessed to have with me today my parents, Donald and Adrian Giss, who have taught me the value of hard work, dedication, kindness, and love. If God gave me a choice, I could not have picked better parents. I also have with me my loving and supportive husband, Steve Benjamin, here with me today. I thank him for his unwavering support of me and all of my endeavors. Steve and I are blessed to have 2 beautiful daughters who are the inspiration for all that we do. We are proud of them, and like any proud mother, if I had more time here today, I would brag on them and probably embarrass them. Also with me today is my cousin, who has been more of like a sister to me, who is an attorney in Atlanta, and I thank her for clearing her schedule to be here with me today. I want to thank my family and friends at home who were not able to be here with me, to include my sister-in-law Cynthia and my nephew DJ, or Donald, who is like a son to me, my in-laws Sam and Maggie Benjamin, and my 96-year-old grandmother who lives in Charleston, South Carolina. I would like to acknowledge my family that are here with me in spirit, my brother and my paternal grandparents who I know are beaming with pride today. Finally, I would like to thank my South Carolina Judiciary family, my court staff, my law clerks, Chandler and Harvey, who are here with me today, and members of the South Carolina Bar for their words of encouragement and support over the last several months. Senators, I look forward to answering any questions that you may have.
Thank you, Judge. You bring the whole package. I looked at your background, having served on the state's courts for many years and presided over 300 trials. Several occasions you've served as acting justice of the South Carolina Supreme Court. You have, for our purposes here on the Senate Judiciary Committee, the wholehearted support of a respected Congressman, Jim Clyburn, and what we call blue slips, which are approval slips from both Republican senators from the state of South Carolina. I don't know how you did it, but you did. And it's an amazing demonstration of belief in what you have produced in your life and what you can produce in years to follow. Now, occasionally you've sat on the South Carolina Supreme Court as an acting justice, so you understand appellate practice, at least from that perspective. After all these years of litigation and trial practice, are you ready to change the lifestyle permanently to become a federal circuit judge?
Thank you, Chair Durbin. Over the course of my career, I have had the opportunity to, as you stated, handle hundreds of jury trials, weighing evidence, considering testimony of witnesses, instructing the jury as to the law, ruling on motions, post-trial, pre-trial, and during the trial. And Senator, I have an appreciation that I think that I would take with me to the Fourth Circuit, an appreciation of the trial courts and the work that they do. I have an appreciation and recognize the limited role of the appellate courts in only considering the issues that are before them. Senator, I have committed my life to this system of American jurisprudence, and it would be an honor and a privilege to continue my service on the Fourth Circuit Court of Appeals.
I have one other question. It appears that you served as Assistant Attorney General for the South Carolina Attorney General's Office and were named South Carolina's State Violence Against Women Prosecutor. What did your work in that capacity entail?
Thank you, Senator. As an Assistant Attorney General, I was the state's Violence Against Women Prosecutor, and I also handled cases involving crimes against children, crimes against the elderly, and I handled, at the time, South Carolina had enacted the sexually violent predator law, and I was one of the, I handled one of the first trials and was successful in getting a civil commitment in one of those cases. I prosecuted cases all across the state. We trained law enforcement on law enforcement on the laws regarding domestic violence and the cycle of violence during that time.
Thank you very much. Senator Grassley.
Congratulations to you.
Thank you.
I'm just going to ask you about one case because it raises some questions in my mind. I just kind of want to know your thinking. This is the Albertus Lewis case. He was he murdered a person by the name of Maya Sanchez and left her outside the hospital door after he shot her. You originally denied bond, and then for some reason you granted bond. I know the case received some attention when you were nominated to the state appellate court. In an interview with a newspaper, you cited, quote unquote, constitutional issues of detention without trial. Unfortunately, while he was out on bond, the police allegedly responded to several domestic violence scenes involving him. At the last one, he used a child as a human shield during a shootout with sheriffs. So is the constitutional issue you referred to the right to a speedy trial under speedy trial clause?
Thank you, Senator. And I'm going to be very careful on how I answer because that case is still pending. Although it is a 2017 case, that case is still pending. He is not, I don't believe he's been convicted of any of those charges. What I will tell you is of public record, he appeared before me for a bond hearing and I denied his bond. It was not until after, I believe 18 months or 2 years later, that after being ordered to try his case, the state being ordered to try his case, that I granted bond because of a violation of the court's order and also a potential violation of the Sixth Amendment right to a speedy trial.
Can you tell me what remedies courts have identified for speedy trial clause abuse violations?
Thank you, Senator. The remedy for a violation of a speedy trial is usually dismissal of the charge. I did not dismiss the charge. I granted a significantly high bond in lieu of dismissing the charges.
Since you didn't do it for dismissal, and you said, I think you would agree that dismissal is the only reason it can be used for a remedy in that instance, right? Did Mr. Lewis raise the speedy trial clause in his motion?
He, if I recall, there was an order from a previous court in which a judge had ordered the state to try his case. So there was an order from the court, and I believe I found I made my decision based on the violation of that order. He also claimed that his Sixth Amendment rights were violated.
What factors do courts consider in deciding the right to a speedy trial has been violated?
Thank you, Senator. Courts consider the duration of the time that the defendant was detained, the reason that the state has given for the delay in trying the case. In that case, Senator, there was no reason given for the delay. There were issues of discovery violations, and therefore I found that it was appropriate to issue a significantly high bond.
Okay, move on to another issue. We always try to get people, particularly if you've been a judge, to kind of describe to us your judicial philosophy. And I'm particularly interested in how you would approach the Constitution.
Thank you, Senator. Over the course of my career, I was on the municipal court for 7 years. I've been on the state, South Carolina State Circuit Court for 11.5 years. I approach each case individually. I look at the facts of the case, I consider the evidence in the case, and then I rule based on the case that is before me. In considering the Constitution of the United States, Senator, I would consider the text of the Constitution. I would use any evidence, any historical evidence to gain an understanding of the drafter's intent at the time that the Constitution was drafted.
So then it seems to me you've kind of described yourself as an originalist. Is that right?
Well, Senator, over the course of my career, I've tried not to ascribe to any titles, but that is the approach that I've taken.
Thank you.
Thanks, Senator Grassley. Senator Whitehouse.
Thank you, Chairman, and welcome, Your Honor. It's good to have you here in the Judiciary Committee. I just wanted to flag that it is increasingly, it seems, the view of some of the members of this committee that a candidate for a position on the bench needs to come before us accessorized with a judicial philosophy. And I want to state my disagreement with that principle. I think that the Constitution and the law, and if you're having any trouble with the language, the dictionary, and some good common sense and adherence to precedent are about all that a judge needs to get it right. And that once we start hearing about judicial philosophy, the next thing we hear about is originalism. And originalism is a doctrine that imparts a strong political overlay on judicial decisions. So not only do I disagree with my respected colleagues that having a judicial philosophy is important, I also think that to the extent that that judicial philosophy is originalism, it is a political signal that is actually inappropriate for judges to bring to the bench. Clearly, an originalist reading of the Constitution takes you back to a time before there were big corporations, before there was any need for consumer protection, before there was any need for antitrust protection, before there was any need for regulation of major polluters. So obviously, to go back to a world before there was a need for any of that sets up a framework where you can attack, or from which you can attack, the regulatory infrastructure that we've constructed to protect people from those big corporations. And I think that many of the proponents of originalism actually have that very proposition in mind when they promote the theory of originalism. So I would simply urge you that there's absolutely no requirement that you come here with a judicial philosophy other than a simple, honest approach to the documents and principles that I've described. And I just want to make that clear because we're hearing more and more about the importance or the necessity or the need or the propriety of judges having a judicial philosophy, which almost inevitably turns out to be what I consider to be a very flawed philosophy and a very political philosophy, which is originalism. You obviously have spent a lot of time doing trials, and that means you've obviously spent a lot of time with juries. Is that correct?
Yes.
So I go back to the founding era when juries were an incredibly important institution for the founders. It was part of the complaint against the British occupation of the U.S. That the British governors had interfered with the right to trial by jury. And if you look at the discussions as we built our Constitution, the preeminence of the importance of the right to trial by jury was really accepted by all. And in fact, there was a huge row when the Constitution was developed and didn't protect the right to trial by jury, and they had to put it into the Bill of Rights in order to get support and move forward. So if you could say just a few words about the importance of the jury, not only as an appendage of the court, a fact-finding appendage of the court, but also as an institution in our system of American democracy. Blackstone, who was probably the person to whom the founders most referred for legal principles, said that the jury was an important bulwark to protect against the power of the most wealthy and powerful in society. And there are obviously a lot of reasons why a jury will do that. How do you feel about juries in that light? Are you willing to protect them as an institution in our democracy?
Thank you, Senator. Over the course of my career, I have had the opportunity to interact with juries, obviously, by being a trial court judge. Juries bring an impartial, fair, unbiased perspective to our judicial system. They are the backbone of our judicial system, and the jury system works. I am often amazed at how our forefounders came up with a system that works today in seeing jurors interact, 12 people who come from different communities, able to come together and make a decision. So, as I stated, the jury system in our country is the backbone of our judicial system.
Thank you, Chairman. My time's expired. Thank you, Judge. I wish you well.
Thank you, Senator. Now recognize recently reelected and returning to the committee, our friend from Connecticut, Senator Blumenthal.
Thanks, Mr. Chairman. I would yield to Senator Hirono. I think she actually was here before me and is entitled to go before me. So
I don't know. Is that right? I don't. Are we following seniority?
Turns out, once again, Senator Blumenthal's right. Senator Hirono.
Thank you very much. Welcome, Judge Benjamin, to you and your family. I ask the following two initial questions, going to the fitness of the nominee, of every nominee who appears on any of the committees on which I sit. So I will ask you these initial questions. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
I congratulate you on having a very strong bipartisan support, and as I've sat on this committee for the number of years that I have, things can get very testy, and it is a testament to you as a person and as a judge that you have received the support of the two senators from your state. I wanted to just ask you, apparently you speak often to students, and as a judge, you can't be that limits your role in a number of instances. But tell me why you think it is so important to talk to middle school students or take other opportunities to talk with young people about the law.
Thank you, Senator. I have always, prior to being on the bench, done pro bono work. Now that I am on the bench, it is difficult to do any type of pro bono work. So I have continuously reached out to schools. I speak during Constitution Day, Career Day. I am proud of my profession, and I am a cheerleader for the courts and attorneys. And so I enjoy speaking with children, teenagers. My daughters will probably tell you that they get a lecture every day about something in the court system. And but I think it's important to discuss civics with our students. I enjoy bringing them to the courthouse and showing them where the jury sits and what a jury does, because often their understanding of our judicial system is what they see maybe on a blurb on TV. And so being I guess, a cheerleader for the judicial system and having the opportunity to speak to young people is one of the great things about my job.
What are the one or two things that you most want these young people to understand about the legal system after listening to you?
What I will often tell young people, and when I'm asked by older people, the thing about our judicial system is that it is not it's not perfect, but it is the best judicial system devised by man. And in this country, if you are charged with a crime, you're presumed to be innocent. If you are summoned to court for jury duty, you have the opportunity to participate in the process. And also, I always encourage them to consider the practice of law.
You were asked whether you are an originalist, and I would just like to add that I share the perspective of my colleague from Rhode Island, Senator Whitehouse, that it is not a matter of trying to get any of our nominees to identify by using a particular designation as to their judicial philosophy, such as originalism, which I consider to be a perspective that does not really result in what I would consider to be the fair and objective application of the law. What I ask of our judicial nominees is that, as you mentioned, to review the facts, to apply the law in a fair and objective way. And that is what I would ask of any judicial nominee. Would you share that kind of perspective, Judge Benjamin?
Yes, Senator. I approach each case individually based on the facts that are before me, based on the law that is before me. I follow precedent in the case and apply the law to the facts in reaching a decision.
Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Blackburn, if you're ready.
Absolutely. Thank you so much for being here. I was just commenting as I was walking back down that you were doing a nice job.
Thank you, Senator.
I was watching it in my office. I think Senator Grassley asked you about the Lewis case.
Yes, Senator.
Okay, and I want to circle back on that for just a moment, because and he asked you about the bond. I want to ask you about the speedy trial. You had talked about that you felt like the speedy trial clause applied on this, but he had been held for 2 years, and the Supreme Court had already held that you could go to a 7-year detention without a violation on that. So explain to me your analysis of why the speedy trial clause required you to release Mr. Lewis.
Thank you, Senator. Anytime that I consider bond, I consider the U.S. Constitution, the South Carolina Constitution, and the South Carolina bond statute. And in that case, once again, the defendant appeared before me, I believe it was 18 months or 2 years prior, and when he appeared before me, I did, in fact, deny his bond. He appeared again, I think, before maybe 18 months later, and at that point in time, the state was missing evidence. There was violations of discovery issues. There was a previous court order in which the state was ordered to try the case, and they had not and could not give sufficient reason as to why they did not try it. And
So that was your premise.
based on the totality of everything that was before me.
All right, but then, you know, he was charged with attempted murder of the 2 police officers after this release, and he used a child as a human shield. So do you regret this decision?
Thank you, Senator. Once again, I based my decision on the facts that I had before me. The defendant was alleging a violation of his speedy trial rights and a violation of the court's previous order. Once again, there is missing.
You're not answering me. Do you regret the decision? If you had it to do over, would you do something differently?
Thank you, Senator. Once again, I based my decision on the Constitution of the United States.
Okay. Let me ask you about Troy Stevenson. He was a defendant charged with first-degree burglary, and you released him on bond, and he subsequently was involved in the murder of a woman who was working at a bakery, and he had a history of engaging in burglary, hung around with the gang, owned a variety of guns, openly admitted to using drugs. And when you take all of this together, and that's information that you had, these factors show that he was a danger to the community. So how do you justify your decision to release him on bail despite these indications, because that is information that you had?
Thank you, Senator. And respectfully, when Troy Stevenson appeared before me, he was a juvenile. He did not have any criminal record. He appeared before me. His co-defendants who were juveniles were released to their parents. They were not detained. He appeared before me because of his age at that point in time, but he did not have a criminal record. Those charges were subsequently dismissed against him, and my understanding from the record is that he was charged for murder. I did not try the case, but he was found not guilty of those charges, on the murder charges also.
All right. My time is about to expire. I do want to ask you about South Carolina versus Statton. You reduced the sentence of a convicted murderer from the mandatory minimum sentence of 30 years to 28 years. And under South Carolina's mandatory minimum statute, a defendant convicted of murder must serve at least the mandatory minimum of 30 years and cannot receive any reduction of that sentence. So given the plain language of that statute, did your decision to reduce this sentence violate South Carolina's sentencing law?
Thank you, Senator. So Mr. Statton appeared before me upon the motion of the state. at the time that he appeared before me, he was detained, and I believe he still is detained at the Department of Corrections. The captain of the Department of Corrections petitioned the court along with the state asking for a reduction in his sentence based on his substantial assistance to the Department of Corrections in handling issues of gang violence. And I believe the captain's exact words was that he unequivocally saved the lives of correction officers at the Department of Corrections in assisting them. And so that motion was brought before me upon the motion by the state. The state statute says that the only way that a motion of that type can be brought before the court is by the prosecutor. And at that point in time, after considering everything that was before me, including numerous letters from the Department of Corrections, I found that it was appropriate based on the statute and everything that I had before me.
Okay.
Thank you, Senator Blackburn. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you for being here, Your Honor.
Thank you.
And thank you for your and your family's record of exceptional public service to the people of South Carolina and to our nation. And I just want to say how proud I am to be on this committee talking to these nominees, including most prominently yourself, who really look like America. They're among our best of the legal profession in America, and I strongly hope that you will be confirmed during this session. The chairman has done an absolutely masterful job of enabling us to reach as many nominees as possible, and I thank him for his leadership. But you have, as he said, the whole package. And I think you've handled the questions here with extraordinary insight and grace. I want to ask you about your experience in the Attorney General's office in South Carolina, most particularly in your serving as the state's Violence Against Women prosecutor. I wonder if you could tell us a little bit about your experience in that role, whether you think that violence against women is a continuing problem based on your experience since then and during that time.
Thank you, Senator. I was hired by the then South Carolina Attorney General to handle violence against women cases, prosecuting cases all around the state, to assisting law enforcement in training in prosecuting cases. I handled a number of trials, a number of guilty pleas, instructed law enforcement regarding trained law enforcement regarding the cycle of violence and how to respond to domestic situations. And I guess the answer to the second part of your question is that I don't have any statistics as to violence, but I think at the time when I was hired, South Carolina may have been number 1 or 2 in the country of men who killed women. And so that is why our state legislature set aside money for a specialized prosecutor to handle those cases. In answering the second part of your question, I'm not sure as to where we are ranked now in the state, but I do know that it is still an issue.
I think our experience nationwide is that the numbers of domestic violence cases has increased, some say because of the anxiety and stress of the pandemic. There may be other reasons as well. We reauthorized the Violence Against Women Act. As you know, I was proud, along with other members of this committee, to be a leader in that effort. And in Connecticut, we have seen the same kind of increase in numbers of cases. So I hope that you will bring to bear, as a member of the United States Court of Appeals, your insights and experience as a prosecutor of those kinds of cases, because I think that our judiciary needs to be attuned to it as well. I want to ask you finally about access to our justice system based on income level, race, ethnicity. Do you think there continue to be disparities in the equality of access to our justice system.
Thank you, Senator. I'm not sure if I'm in a position to be able to answer any question regarding any disparities. I do know in South Carolina that we have our court and our Supreme Court is looked at the issue of access to justice, and that we have a commission that studies access to justice.
Thank you. Thanks,
Thank
Mr.
you.
Chairman.
Thank you, Senator Blumenthal. Senator Cruz.
Thank you, Mr. Chairman. Judge Benjamin.
Good morning.
Good morning. There has been considerable discussion nationally about policies of Democratic district attorneys and Democratic judges releasing violent criminals who in turn around and commit more violent crimes and make our communities less safe. This has been a problem plaguing the country as we've seen crime rates skyrocket and murder rates skyrocket. And it is a problem that is exacerbated by the Biden administration and the Democrats in the Senate who continue to further the priorities of releasing violent criminals. When I look at your record, I see a pattern of doing the same thing. You're very familiar with the case of Albertus Lewis. Albertus Lewis allegedly shot Myra Sanchez in the head and then dumped her body in a wheelchair outside of a hospital in downtown Columbia. You granted Lewis a surety bond in the amount of $150,000. After you did so, it turned out that Lewis was involved in yet another violent incident when police responded to a domestic violence scene involving Lewis, where a woman called 911 saying Lewis had a gun and was setting things on fire. When police arrived, they had to fire almost immediately because of the danger, and they had to go in because Lewis picked up a small child and used a small child as a human shield, in the process causing injury to two sheriff's deputies. Do you think it was a mistake to release a violent criminal on bond when he went out and committed yet another violent crime?
Thank you, Senator. As I previously stated, Mr. Lewis, when he initially appeared before me, I denied his bond. It was not until after the state violated the court's order to try his case. There was issues with discovery missing in the case. And Senator, and I'll just say this, the case is still pending. It's a 2017 case. It is still pending. There's issues with discovery in the case, and the defendant was asserting his right, Sixth Amendment right to a speedy trial. That was after 2 years when he initially appeared before me, and I denied his bond. In considering any bond, Senator, I consider the United States Constitution, the South Carolina Constitution, and I have to consider the bond statute of the General Assembly in South Carolina.
Okay, so you just said you did it because of a speedy trial claim. What is the remedy for a speedy trial claim?
The remedy for a speedy trial claim is dismissal. So
you didn't do that, did you?
My consideration was based on him violating the court's previous order of not trying the case. It was
By the way,
not
what's
based-
the Fourth Circuit precedent on speedy trial claims? And isn't it in fact the case that the Fourth Circuit has repeatedly held that substantially longer delays don't violate the speedy trial clause?
Well, I think there's an analysis that has to be done.
Did you engage in that analysis?
Yes, and part of that analysis is that the state has to give a reason as to why they did not try the case. And in that case, the state did not have a reason whatsoever.
So you said you engaged in that analysis. Did you write an opinion? Did you explain your reasoning from the bench?
I don't recall. I do not recall, but we do not usually have published opinions in South Carolina.
Well, you know, the court they've appointed you to, that's what they do. And
yes, I understand that.
So I'm going to give you a chance to answer my question again, because I started with, do you think it was a mistake to release a violent criminal who turned around and injured 2 sheriff's deputies and held up a little child as a human shield? Was it a mistake?
Thank you again, Senator. Once again, I consider the issues before me. I consider the Constitution of the state of South Carolina, the United States, and the bond code. And
But
I
you know,
made my
that's
decision
not any
based on
comfort
that.
to the families of the sheriff's deputies who were shot by the violent criminal you released. And you have a pattern of doing so in other cases as well, including releasing one of the people involved in yet another murder of Kelly Honeywell, a 33-year-old single mother of 4 who was murdered, shot during a robbery, and you released one of the individuals involved in that. And listen, what I find amazing is the Biden administration claims they bear no responsibility for releasing violent criminals who turn around and murder people. But then President Biden keeps nominating judicial nominees who have a history of releasing violent criminals who turn around and murder people. And every Senate Democrat's going to vote to confirm you, and they're going to go home and tell their constituents, oh, we don't support releasing violent criminals who turn around and murder people, and yet we keep following this pattern over and over again. There's a reason people are very concerned about the safety of their families.
Senator Booker.
It's good to be back, Mr. Chairman. It's an honor to be before you, Judge. I'm grateful. I just want to take a moment, though. You know, it's tough to see issues of crime become so weighted in partisanship in our country when we all share the same values. We all want safe homes and safe communities. And the way data is often parsed is such a venal kind of crass partisanship. I look at the country right now, and the majority of the states with the highest per capita murder rate have been so-called red states, and I don't think that's a Republican versus Democrat thing. And to use these things to whip up makes me appreciate the weeks I had away from Washington, D.C. Because out in America, people want us to come together and find solutions. And again, it's frustrating to have this thought that this Congress has approved hundreds of millions of dollars for public safety, one of the largest investments public safety has been made in generations to help local police departments. We've expanded COPS grants, SAFER grants. A lot of this has actually been money that has been voted against by some of my very colleagues who are somehow making this fiction that the Biden administration has not been one of the best in supporting and empowering local police departments. Again, this is not a partisan issue. I'm not going to wave a flag that says that the highest per capita murder rates are in red states, Republican states. I mean, that would be, in my opinion, venal, crass, and not indicative of the common cause that we have in preventing crime. Nor would I look at all the judges that Donald Trump put up and scrape them to see what was said as if it's only the judges that from one party that have, in any point in their lives, released somebody who's gone out and committed a crime. I worked with the Trump administration to pass incredible criminal justice reform that literally had thousands of people released from prison when we worked, sir, on your bill that corrected the failure to make retroactive the crack and powder cocaine situation. And less than 1%, I think, went out and recidivated. That's not an indictment of the Trump administration. That's not an indictment of him. And that's the kind of rhetoric that's just getting tiresome to me. Murder started to spike not under the Biden administration. Murder rates started to spike in America under the Trump administration. And so, again, I'm back here. I need to readjust into this environment, into this into listening back and forth, but I am frustrated that it's happening before a judge who is just extraordinary, whose career is a testimony to the best of what it means to serve this country, not in a partisan way, but in a branch of government that's independent of partisanship, who's sitting in a chair making tough calls every single day And now what I see is often a pattern that I've seen in Supreme Court, in a Supreme Court hearing now, all the way down now to the federal judiciary, to try to create this fiction that somehow judges who have to make tough calls, judges appointed by Republicans and Democrats, often have to make tough calls and have to evaluate the law and make decisions. And I think that your career is a testimony to that. I want to thank you for being here. I want to praise the family that raised you. I want to celebrate your service and let you know that I'm looking forward to voting for you on the floor of the Senate. You will be confirmed, and it will be a great day for America. And so let me just end in the 30 seconds I have left and just asking you to say on the record your understanding of your role as a judge in the face of a nation that has more and more partisanship, it seems, a greater culture of contempt. You're coming forward, and I think your career is a testimony to that, with an understanding to the responsibilities of the judiciary. And you will hold on this circuit court position, which I'm confident you will have, a sacred obligation that you will fulfill. And I was wondering if you could just take my last seconds and affirm that to this committee that I don't think needs the affirmation, but I want to give you space to do so.
Thank you, Senator. In any decision that I make, I consider the text of the Constitution. In my current role, I consider the South Carolina Constitution and the law that is before me. Senator, I take seriously the oath that I have taken to uphold and protect the Constitution of my state and of the United States of America.
And not only do I hear your affirmation, but I am grateful for that commitment. This country needs more of that. And I thank you for being here. And again, Mr. Chairman, I look forward to casting a vote in favor of this extraordinary human being.
Thank you, Senator Booker. Senator Kennedy?
Thank you, Mr. Chairman. Judge, congratulations.
Thank you.
I want to try to understand the facts on some of these cases.
Yes, sir.
The Albertus Lewis case. He shot his girlfriend in the head. Is that correct?
Senator, as I stated, I'm not sure if you were in here earlier, that case is still pending. He's not been convicted of any of those charges. And so I have to be really careful in how I frame my question.
Did he shoot his girlfriend in the head?
Senator, based on, those are the allegations of the charge, yes.
So you're saying he didn't shoot his girlfriend in the head?
He has not been convicted of anything, is my understanding. And I know it's a very old case. It's 2017.
Well, when you granted him bond, did you think he had shot his girlfriend in the head? He was charged with shooting his girlfriend in the head, wasn't he?
Thank you, Senator.
You're welcome.
Those are the allegations. When he initially appeared before me,
okay,
I denied his bond based on everything that was before me.
Let me start over. Okay. Mr. Lewis was charged and arrested, so presumably there was probable cause, with shooting his girlfriend in the head and putting her body in a wheelchair and dumping her outside the hospital. Those were the allegations. Is that right?
I believe those were the allegations, yes, sir.
Okay. And you gave Mr. Lewis bond. Is that right?
No, that's incorrect, Senator. I denied his bond. When he appeared before me in July of 2017.
So you didn't give him bond? He didn't release him?
I denied his bond. It was 2 years later.
Did you ultimately release him?
2 years later, after the state violated the court's order.
Did you grant his bond? I'm just trying to understand the facts.
Yes, sir. 2 years later, after the state.
You granted his bond?
When he initially appeared before me, I denied the bond. It was 2 years after that I granted a bond.
You did grant the bond?
After the violation by the state of the court order to try his case and discovery rules.
And then he went out and tried to kill 2 sheriff's deputies while using a baby as a human shield, allegedly. Is that right?
Those are the allegations in the other case, yes.
Okay. would he been able to do that if you hadn't let him go?
Thank you, Senator.
You're welcome.
When he appeared before me, I denied his bond. He appeared before me again, at which point.
And you let him go?
The state violated the order of the court.
But I'm just
and I said a sufficiently
You
high
let him
bond.
go. If you hadn't have let him go, then he could not have tried to kill 2 sheriff's deputies using a child, as a human shield. Factually, is that correct?
I'm not sure, Senator.
Oh, I think you are. Let me ask you about Kelly Honeywell. You remember that name?
Senator, I did not have any involvement in that actual case, but I am familiar with what you're referring to.
Okay. Do you remember Troy Stevenson?
Yes.
All right. Troy Stevenson was arrested, allegedly, for shooting Kelly Honeywell, killing her, murdering her at a bakery. Mr. Honeywell was arrested. And Mr. Honeywell allegedly was a member of a gang. He owned guns, and he did drugs. Okay? You granted Mr. Stevenson bail. Is that right?
I didn't, in that case, I did not set bail bond in that case when he was charged with murder.
You didn't let him go?
I did not set the bond on the murder charge.
Who did?
I don't know who's, one of my
How did he get out of jail?
Are you asking about the murder charge?
What I'm asking, and I think you know what I'm asking, Mr. Stevenson allegedly was arrested for shooting this bakery worker in the head, and he was granted bail. He was let out. You didn't grant the bail?
No, sir.
Who did?
My understanding is his bond was denied in that case on the murder case. Mr. Stevenson, I believe, after trial, was found not guilty of those charges. But I did not set the bond on the murder case. I did not try the case on the murder case. I did not set the bond on the murder case.
Okay. I think I'm out of time. Thanks, Judge.
All right, thank you.
Senator Lee.
Thank you very much, Judge Benjamin, for being here today.
Thank you.
Let's talk about your approach to reading statutes, to construing them. How much weight do you give to the plain meaning of the text of a statute when construing it?
Thank you, Senator. In considering a statute, the first thing that the court must consider is if it is clear and unambiguous. If it is clear and unambiguous, the analysis stops there. If it is not, I would then, the Supreme Court has said that it is appropriate at that point in time to consider the text once again, the principles of statutory construction, and also that it is appropriate at times to consider legislative history.
Okay. And when we talk about the plain meaning of statutory text, are we talking about the plain meaning as of the moment of enactment, or does the time in question and therefore the meaning of the text in question evolve based on changing social conventions, social norms, linguistic conventions, and so forth over time?
I believe that it's gaining an understanding at the time that it was adopted.
The time of enactment. Now, you were the judge assigned to a sentence reduction petition in a case called South Carolina versus Staten.
Yes, sir.
I hope I'm pronouncing that correctly. It's a case that involved a defendant who had been convicted of murder. He was serving a prison term sentence, a minimum mandatory term of 30 years. As I understand it, you decreased the sentence of the defendant to 28 years rather than 30 years, based on some assistance that he had rendered to the police, to the Department of Corrections officer who was assigned to a case. You did this even though South Carolina's murder statute clearly states that no convicted defendant is eligible for parole or for early release or for good time credits of any kind under these circumstances. How did you decide that early release for that defendant was appropriate in spite of the statutory language?
Thank you, Senator. In considering that statute, I looked to the statute. I considered that statute was enacted after the mandatory minimum statutes. The statute specifically states that the motion can only be brought on the motion of the state or the prosecutor or the attorney general. That motion came before me on the motion of the state of South Carolina based on the Department of Corrections request for a reduction in the sentence. And I believe the captain of the Department of Corrections exact statement was that the defendant had unequivocally saved the lives of corrections officers. The title of the statute is titled Assistance to Law Enforcement or Department of Corrections. Our Supreme Court has stated that it is appropriate for courts to consider the fact that the statute, that the legislature was aware of other statutes at the time that they enacted the statute, and nowhere in the statute did it discuss mandatory minimums.
Is there any reference in that subsequently enacted statute that directly references crimes that carry those statutory minimums?
No, there was not.
Yeah, and that's what concerns me, is that the statute in question, the statute that I believe bound you, states, quote, no person sentenced to a mandatory minimum term of imprisonment for 30 years to life pursuant to this section is eligible for parole or any early release program, nor is the person eligible to receive any work credits, education credits, good conduct credits, or any other credits that would reduce the mandatory minimum term of imprisonment for 30 years to life required by this section. And so when there's a statute that's that clear, if there is then a subsequently enacted statute that makes no reference to a mandatory minimum sentence, seems to me to be a stretch to do this. And yet you've acknowledged that there's no reference to that statute. In other words, there's nothing that supersedes that.
No, Senator, the only thing that I can tell you is that in that statute, that the substantial assistance to law enforcement statute, the General Assembly gave great deference to the prosecutors in the state and also to the Attorney General to bring the motion. That motion cannot be brought by anyone else. It was brought to me based on the motion of the state of South Carolina to reduce the sentence based on the substantial assistance. The case law in South Carolina says that our Supreme Court has instructed trial judges to assume that the General Assembly was aware of the subsequent statute at the time that they enacted the new statute, which would have been the substantial assistance statute.
Okay. I see my time's expired. Thank you, Judge.
Thank you.
Judge Benjamin, how many years have you been a judge?
I served on the municipal court for 7 years, and I have been on the South Carolina Circuit Court for 11 and a half years.
Our staff estimates that you've issued thousands of opinions. Is that likely to be true?
I have handled thousands of cases, and I've tried several hundred jury trials.
And how many of your decisions have been appealed?
I believe the number is like 51 or 61 or something like that.
That's what we found too. Somewhere right around 59 is our guess. And how many times have you been reversed? Has the higher court looked at your decision in a case and said you violated the Constitution and the law?
I think I've been reversed maybe 11 times.
We have 10. So we have thousands of cases that you have sat on as a judge and hundreds of cases that you have tried, and we're able to find 10, maybe 11 times that the higher court said you got it wrong. So that would put you into kind of the, I don't know what percent, 99.9% category of getting it right. I sure wish senators had that record. It would really make life a lot easier for us up here, too. And it seems to me, unusual that the other side of the bench here has really just focused on one case, a case which you explained that you denied the bond on, and a man was incarcerated for 18 months afterwards, and then the state wouldn't even go forward with the prosecution and violated a court order demanding that they do so. This was an extraordinary case, was it not?
And Senator, once again, I have to be careful because the case is still pending.
Right.
The case is still pending, yes.
I just find it interesting. They found one case. Thousands of cases that you have, they found one case. And it's arguable, let me just say it in my own words, you don't have to agree with or not, to base a decision on the future of your life on one case. A complicated case where even the state of South Carolina was admonished for not handling it properly. So that is what this is about. Sometimes one of the witnesses will come and they'll find something they wrote in college when they were freshmen, and we'll spend an hour talking about an article that a freshman in college wrote. That's the right of the members of the committee to choose what they wish in a person's background. What I choose to dwell on is the fact that you have an extraordinary background as a judge, extraordinary. And the fact that you've only been reversed 10 or 11 times out of thousands of cases tells me what the American Bar Association also told me. You're qualified to serve on the circuit bench, and I thank you for appearing before us today. Thank you very much.
Thank you.
We now have a second panel of judicial nominees.